Good morning, everyone. We've got a couple more minutes before we get started, but I started recording. If anybody has any questions, please put them into the chat. I am going to talk about PPP loans and forgiveness, but this is also an Ask Me Anything. I'm going to address some other things that are related, COVID-related, employee issues, employer issues, and a few other things. But if you have any questions, please ask them. Karen, we did get yours that got sent over by email from the person that you sent, but if anybody else has any others, please, like I said, send them in the chat. If you do not have a chance to have your question answered, or you think of it later, because that happens too, please either email it to me at jenglert@theorlandolawgroup.com or put it in our Facebook page as a message, or in the webinar, either the advertisement for it or the link. We will also post this on our website in our COVID resources, and we will have it on our YouTube channel. Please like and follow our YouTube channel. We're trying to get to the 100 so that we can have our own URL, which will make things a whole lot easier for us to use. So I will start with a few other things before I get to the PPP part. I will talk about the PPP a few minutes in. That way it gives people time to get on. But I'm going to start by talking about waivers. If you have a business, this is HOAs too. This is a real hot topic if you're on your HOA board, or you have an HOA and your amenities are still closed, or if you own a business of any kind. There are waivers that I suggest that you do have your clients / patients / whatever sign. We do have a standard form that we can kind of share with you. They should be customized. Now, I think the rule of thumb is, and I see Bob is on there as my insurance agent, and he would probably echo this, if you have a business insurance policy, most people believe that that will not cover any damage from anything that happens if somebody claims that they got COVID in your facility or your business. If you're an HOA in your common areas or your pool or your gym or any of that. I think if you're on Facebook or anywhere, if you're not under a rock, you're seeing that some businesses, it's being posted that people or patients or clients have COVID. I'm seeing businesses deal with this any number of ways. Some appear to be dealing with it really well, and some appear to be completely ignoring it. That's my ostrich syndrome. You know, I hate ostrich syndrome if you watch me ever. So completely ignoring it probably is not the best thing, although some people are going to do that. So probably not going to have insurance coverage for this, which is why we have to do everything we can to maximize our ability to fight any type of lawsuit if somebody sues you for getting COVID in your business. Now, is it a silly lawsuit to do that? Yes, I agree it is a silly lawsuit. It's going to be very difficult to prove that anybody got COVID in your business. I've defended restaurants with food poisoning cases and things like that, and it is not easy to prove, but that does not mean that people will not sue for it. It does not mean that your employees won't sue you for it, and it does not mean that your clientele will not sue you for it. So a good rule of thumb is to use the waiver or a waiver of any kind. Something is better than nothing. There's some elements that I'd like to see in it, including that there is risk of COVID everywhere, including that you have people in there certified that they haven't had a fever, that they have no symptoms before they come in to your facility or partake of whatever you have to offer, and a few other things. But if all else fails and you're a little bit concerned, think about having a waiver. If you're somebody who has employees, you can do the fever checks and ask them about their health and whether they're having any symptoms. And I encourage you to do that. We've talked a little bit about this in a couple other webinars. That is something you should be doing. You also are permitted to require a COVID test. One, if it's if they have symptoms or if they don't have symptoms, if you just want it for them to come back to work. That is allowed. The Department of Labor and OSHA is allowing it. You are not violating anyone's rights if you require employees to get any type of COVID testing or take their temperature or ask them about symptoms. Do remember, though, that is protected health information. It is protected by HIPAA. So if you are doing that, do it in a private area. Keep the records private if you are like writing down temperatures, which I think you should be doing. There's something, if you're in medicine, if it's not documented, it's not done. So if you said you took temperatures and you don't have it documented, or you said that you asked about people's symptoms and you didn't document it, it's a lot more difficult to prove. But just keep it under lock and key, because it is private information. It is protected by HIPAA. And if you violate that, then you're a violation of HIPAA, which comes with a fine per violation. So it doesn't take long to get up into a high dollar figure just by a HIPAA violation. You do have to pay employees for the time period that you are taking their temperature. So if you're like they clock in before they do the temperature, that's already been decided. As you can tell, people are already challenging everything under the sun, and it hasn't, I think we just hit 100 days. So all the stuff I'm telling you is stuff that has already been challenged, and there's rules and guidelines out there. So you do have to pay people for temperature. One thing you cannot do is you cannot require your employees to take the test for the antibodies. So you can require them to go get a test to see if they are COVID positive, and not slightly positive or a little positive. I've heard all kinds of things. We were laughing in the office today from one of the questions. A positive test is a positive test. If you had a negative test after, or a variety of positive and negative tests, like I said, I mean, just be careful with the language that you're using if you're putting out there to your clientele that somebody did or did not have a positive test, whether it be like a client or a customer or one of your employees. But so anyway, you could require the test, but you cannot require the antibody test. I know that seems totally crazy and makes no sense, but there's OSHA guidelines on that. You cannot require an employee to take that. Now, will that change? Potentially so. I think you know at this point, I'm monitoring everything under the sun all the time. And we are putting stuff on our Facebook page. We're blogging about this stuff as stuff becomes, new stuff comes out. And I'll continue to do these webinars when there's enough information to put out there. So keep paying attention and follow us, but do know that that's kind of the distinctions right now. Now, I was asked, one of the questions we were asked, and it fits in here, so I'm going to answer it now, is somebody who has sick or vacation time who wants to be absent from work when they've heard that there's a positive COVID test. There's, again, like I said, there's been all sorts of reactions by business owners with a positive COVID test. If you have a positive COVID test, the best thing to do is probably tell your clientele and things that it's out there. Take it head on. Do some type of cleaning. There's a whole bunch of stuff about how you should potentially clean. It is a gray area though. There's not a whole lot of good stuff out there. There are CDC guidelines. But that aside, if your employee does not want to be there, you should not make them be there. So, and I have heard a whole lot of this where people are making employees still come in or saying they need to come in. That's just a bad idea. It's a bad practice. It's going to get around in social media. Social media can kill you. I think we all know this, but also, especially if they've got vacation time or sick time, you let the people use it. If they don't have any of that, you can let them off without pay. Whether that's going to be covered by unemployment or not, I don't think so. There is some new stuff coming out, though, if they're immunocompromised and they really should be out. But at that point, then we're kind of in the doctor's note territory. And we're going to talk about that a little bit with the PPP loan forgiveness. So I'll save that for there, because that's part of how we can get our loan forgiven if we don't get all of our employees back. So now I'm going to go into the PPP loan part. The rules have changed for probably the 7th time. I looked at, it's like, this is the 6th provisional guideline to the 3rd rule change or something as crazy as that. I was going to write it down, but it's pretty close. It's insane. I do believe probably there'll be 1 or 2 more rule changes. The PPP loan cutoff is June 30th. So if you have not put in for this loan by June 30th, you are going to be out of luck. Some banks are going to stop before that. So if you were thinking about doing it, it's the time to do it within the next couple days. There's going to be other resources if you didn't do the PPP loan, but in light of everything that they've done right now to make it easy to apply and to make the forgiveness fairly easy, if you haven't done it and you've been thinking about it, you should do it. Now, if you have put in for it already, there are basically two sets of guidelines that you can use now, and now I'll tell you a little bit about that because it's changed pretty much dramatically between what it started out with for forgiveness and what it is now. There are two loan forgiveness applications. The last webinar I gave was on, there was only one, and now there are two. Now there is the EZ form, and yes, it is the EZ form, which is awesome, and it would be great if you could fit yourself into that one. I have it in my hand, and it's only 2 pages long, and really all the meat's on the first page. This basically can be used if you have pretty simple payroll. If you are the owner and you're getting payroll on W-2, you could use it like that. If you're getting draws or you're getting a partnership, you're going to have to pop to the other form. But there's a whole lot of clarity with that also now. When we were first doing these, we weren't really sure how it was going to look like for the owner's compensation, but now that's super clear. So a lot of the gray area and stuff we didn't know is cleared up. But if you do the EZ form, you basically just have to say what your payroll schedule is. You put your payroll costs, which have pretty much settled as well. It is anything that you're putting in 401k, so that's now clear. Anything you're putting in for medical insurance of all kinds, medical, dental, vision. There was a little bit of talk about that was getting dropped out, but it is not. And the actual payroll costs. Payroll taxes that you are paying for your employee, the employer portion, that does not count. So when you're doing your calculations, you need to make sure that you drop that out. The business rent or lease payments, that's been pretty clear across the board. That's still in there, very clear. That's pretty straightforward. And the utility payments, that's pretty much been in there since the beginning. Utility includes internet. At one point, we weren't sure about that. But so that's phone, internet, electric, water. Again, pretty straightforward, and it's very all-encompassing. One good thing that they changed in this newest round is that they dropped the percentage that you have to do for employee income down to 60%. So the last time we did one of these, in order to get your loan forgiven, you had to spend 75% of it on employee salaries and 25% on all the other things, the rent and the utilities. You could have gotten forgiven less, but to get full forgiveness, it had to be at least 75, 25. Now they dropped it down to 60. But now it is a cliff, which means you have to spend at least 60% of whatever you got in your PPP loan on employee expenses, payroll costs, it's called on the form. And that includes all the things I just mentioned. But if you don't spend at least 60% of what you got on the PPP loan on the employee expenses, then none of it's forgivable. So, I mean, again, they want you to spend this on employee expenses, depending on how you do your, if you're the owner, how you do your compensation, that is either included or not included. And we'll talk about that on the long form. Then basically you add all that up, you put the loan amount in, you do the 60% forgiveness, and then basically you add it all together and you're done. So this is super simple. If you've got a payroll service like ADP or something, probably there's forms in there, like they do the report for you. We use ADP, but I know all the other ones are doing it too. So they make it super simple. Now on the longer form, this is one that you need to use. The first couple lines are the same with the utility, the payroll cost, super simple, but that bumps out the payroll cost and you add a little bit more in there. This also includes if you have to mess with the number of employees you had. Because again, they want to see you have basically the same number of employees or employee hours during the PPP loan period time that you had before it, because they don't want you using all the money for stuff like to pay you as the business owner, as opposed to keeping your employee count up. We'll talk about that. So the longer form goes into the Schedule A and the Schedule B, which we talked about in our last seminar. You break down the health insurance specifically separately. You break down the retirement plan money that you pay out, the 401k or whatever specifically. It helps you break out the state and local taxes. Again, we don't have a whole lot of that here. We have less in Florida than in other states, but you still break it out all very specifically. And you break out the money that you pay the owners if it's a draw or a partnership, not W-2 wages. W-2 wages goes in there also if that's how you do it. But if you don't use W-2 wages and you pay yourself in a different way as the owner or the set of owners, you're allowed to put that into this calculation. So again, if you're a partnership, you're using the long form. If you do draws or bonuses as the owner, you're using the long form. If you don't want to get that forgiven and you've kept that separate all along, you don't have to do that, but otherwise you do. The second part of this is they want you to verify whether you have the same number of employees or the same number of hours. So say you change the number of employees, because some people have all sorts of part-time, half-time employees. And remember, according to this, anybody who's under 40 hours is a part-time employee. So it might be that you ended up, because you had to restructure your business in some way, that you had 5 full-time employees, say you had 10 part-time employees, but now you have 5 full-time employees because of the way you had to redo things. Something like restaurants who had to repurpose and don't have as many servers. If you're a medical office and you had to cut hours, basically any type of business that had to change the way they deliver services might have a different number of employees, and in fact, less employees, but the same number of hours. So you are allowed to use either calculation, and the long form walks you through all that. Again, if it's straightforward, same number of employees, like if you were a smaller business and you only had a few, or you were by yourself, then easy is easy and you use it. If it's a little more complicated, you're probably going to have to use the second form. We're using the second form because we just have to. So knowing that everything expires on the 30th, the original loan time period at one point was 10 weeks. Now there is 2 choices. It's either you have to spend all the money over an 8-week period, and people who are in it now, I mean, we had budgeted for that, so you're the 8-week period. But you also have an option of a 24-week period. So if you're somebody especially that had to really reduce hours, staff, shut down for weeks, it might make more sense for you to spread it out over 24 weeks, because in the hopes that between now and the end of the year, because then everybody will have to be finished with their PPP loan payouts by December 31st. If you pick the 24 weeks, the hope is that everything will pop back to normal. You'll have close to the same number of employees, and that you'll be able to use all the money that you took in the PPP loan for over the last basically 6 months of the year. So, okay, make sure I go back to that question, please, Stephen. So, depending on when you take the loan time, the covered period for looking to get your employees back to the 2019 level is February 15th to June 30th, if you're in your PPP loan now and you're trying to do the 8 weeks. But if you're wanting to do the 24 weeks, you have till the end of the year to get your employee count or the hourly rate time period. And that would just be basically adding up all your employee hours, dividing by 40. You can round up to the nearest 10th, and then seeing if the hours are the same. Again, depending on how you do that, your ADP might be helping you with that. But if you had a lot of people on salary like we do, we have to do the calculation manually. If you're having trouble with that, or it's a challenge, it's probably worth getting your accountant or somebody to help you with that, because again, in the long run, it'll pay for itself. The payback time, if you don't get your loan forgiven, has been extended to 5 years. At first it was 2 years, so it's 5 years. Again, important, if you hit that cliff and you don't get the 60%, if you don't get that 60%, there's something you could do to get to it. If you're having trouble, let me know, because we've had some creative solutions for different clients of mine. But yeah, you have to get to that 60%. But if for some reason you don't, at least you could pay it back over 5 years instead of 2. I also had said put it in a separate bank account. If you haven't done that, it's not too late, because it's at least right now, it looks like you're not going to have to provide any specific records for the SBA. But remember, the bank that you got the loan from is the one that's going to do the paperwork to forgive with. So you're going to fill out this application, but they might ask you to do some additional documentation. I haven't got our list yet. We ended our period at the end of last week, but I haven't got the specific list of what my bank wants, but they're going to want something. So just because there's this easy application, which looks awesome, you probably will still need some other records. So keep doing your records the way that you were. Be real careful about it. Now, again, you're still at the $100,000 per employee cap. So even if you're doing the 24-week thing, you're still stuck with that. Although the breakdown is if you're doing the 24 weeks versus the 8 weeks, you just multiply that out, but you're still stuck at that $100,000 cap. Now, if you're an owner and you're being compensated, there is new regs about how that should be done because there's some caps on that too. So even if you do W-2 wages or you're doing the partnership wages, they've decided to cap it based on percentage of profits. So basically you take your profits for the year, and if you're doing the 8-week, you're capped at the 8-week percentage of profits. So you take your profits, divide it by 52, then times it by 8. That's all you're allowed to pay yourself and still have it be forgiven. Or if you're doing the 24 weeks, then you just do the calculation over the 24 weeks instead of the 8. But again, they don't want you to use it as a windfall and like fire all your employees and take all the money as the owner. I don't know anybody who's doing that, but probably someone is doing that somewhere. So you're not allowed to do that. You are allowed to take your mortgage interest. There was some question about that, but you are. Like I said, rent payments are pretty easy and utility payments are pretty easy, but the mortgage interest was a question. It's not just the principal, it's the whole thing is forgivable if you own a building. If you do, again, and you weren't paying yourself rent, there's all kinds of ways to do that. But if you have a building and you aren't paying rent, we should probably talk about that because there's a way to back into that, and you should have been doing that anyway. Probably should have that building in a separate LLC, but that's a seminar for another day. Again, though, the point is run your business like a business. And if you've kind of not been, because it's just easier not to, doing this gives you, running it properly helps get you tax benefits. And in situations like this, it would just make it really clear what your rent amount was. But if you haven't done it, it's not too late. I've helped people get that set up if they haven't done it properly or whatever. So again, that's a hot topic if you haven't done rent right, or it's also a hot topic if you're not sure how much to pay yourself if you're an owner and you didn't have just a set wage all the time, or if you end up having extra money to spend to get up to that 60% because you did have to lay people off. Then we could talk about how to do that strategically. Now, you do have to say you have employees that don't come back for whatever reason, because they can't come back, their doctor won't clear them, they're immunocompromised, they have relatives that are immunocompromised and they want to work from home only, any number of those things. If you have tried to bring your employees back, then, and they don't come back, then you theoretically can add them back to your employee account. The good wisdom is to write a letter offering them their job back. Some people have gotten this already in any number of ways. Some of them have been super transparent and some of them haven't been. But if you've got employees that haven't come back, make sure that it's clear that you did offer them their job back. But now they've also added in that you have to be able to show that you cannot find someone similar to come do that job. So if it's like a clerical job or something like that, they still want you to try to go out and replace it even if the person doesn't come back. So those are all things to consider regarding the loan. But overall, it has gotten a whole lot easier to get the forgiveness. They haven't peeled anything back. And if you could do the 8 weeks, awesome. If not, you could at least do the 24. That means so you won't be applying for the forgiveness probably until 2021. Because you will need to have your payroll tax returns and everything done. And usually that's at least several weeks behind. It just depends on how the quarter falls. But so that's kind of the most up-to-date information. We'll probably have one more of these, but I don't think it's going to change a whole lot more. And after the 30th, when it closes, there might be one more guidance and then we'll probably be done. Now, if you still need some money, because people have been asking that too, and you applied, you're probably getting solicitations for private loans now. We've been getting them. That information was shared with the world, unfortunately. So banks have been contacting us. There are some private loans out there at a fairly decent interest rate. You can go back to the SBA and potentially get a regular SBA loan. They do have some programs. Orange County has a program, and Osceola rolled out one as well. It looks like, or they're about to, for $10,000 grants. That's the Orange County Cares grants for small businesses. I think it was in the news that they were doing the 1,000 per person, but though you can get up to 10,000 for a business as well. So you should try that. And then pretty much that should probably be the end of these programs for now. If you want to work on SBA or any of that, then again, you could contact us and we could kind of set you in the right direction. I'm not going to put all that out in our chat and stuff yet because it just gets confusing. Once the 30th comes and the programs close, we'll relook at everything. But some of the stuff that was already out there is still out there besides the PPP. And I think people will turn to the stuff that's not the PPP loan. Orange County Court has closed again. They went back to level 1 today. Nobody's sure why, but I'm sure that'll come out pretty quickly. But all the courthouses again have closed. They had moved on to level 2. That's important if you're a business and you had done some small claims stuff. Small claims now is up to 8,000. It used to be 5. But if you were either doing evictions or trying to collect, I had some employees who were paying or who were suing for salary and commissions and things. Like I said, some businesses pulled shenanigans and tried to not pay people. Stuff that happened even before COVID. We have, like I said, any type of collection, HOA collections, evictions that were already in the hopper before the court shut down and eviction shut down. They were getting set out. They started getting set again into September. It might bump again. So we'll update you on that on our Facebook page and stuff as well. But it looks like evictions and small claim stuff was going to start up again in September. That is done in person because you do a little mediation when you have that bumped. Trials, they are going to start doing trials in Orange County by Zoom. A few people have done it. It's grueling, and they say add double the time to it. That's probably going to keep continuing and continue through the rest of the year. But again, if you're in litigation in any of the local counties, it is going to stink. It's going to be a while. No eviction or foreclosure has been extended any longer. We'll keep you apprised of that as well, but we expect that foreclosures and things will start back up. We have foreclosure hearings and things starting again in July. If you're on the bubble with any of that, especially with a foreclosure or an abatement of rent or mortgage payments or any of that, now's the time to be super proactive and make sure that whatever arrangement you might have reached with your landlord or your mortgage company, that you make sure that it's in writing and it's taken care of now. We're sort of at the intersection of the downturn in bankruptcy. We are starting to get bankruptcy calls, and we're starting to get calls about student loans. Student loans had been on deferral, so if you're in deferral, you're still going to be for a little while longer. However, your income might have drastically changed over this time period. We do have a lot of people, obviously, that lost jobs or lost income. So there are all kinds of deferments for student loans and reorgs that you can do. If you're thinking about doing that, now's the time to have a consult on that as opposed to wait. Same for bankruptcy. If you think that's a possibility, it's a whole lot better to get a bankruptcy consult. They're free consults, and kind of see where you are. It might help you decide what bills to pay, what bills not to pay. If you've got a chunk of money that you saved or a bonus or a something, there's ways to theoretically spend that strategically. Car tires, new air conditioners, things like that that you might need for your house anyway, and it helps us plan. A lot of people, again, ostrich syndrome, they wait till it's just way too late to do very much and then have an emergency consult and then need to file something right away. We can file a bankruptcy in a day, but it's sure a whole lot better to plan for it. We had a lot of people, especially at the beginning with businesses that had arrangements with a bunch of different people with leverages that we've started to work through. But again, if you feel like you've got an issue, have a consult. At best, it'll make you feel better because you'll have a plan. I mean, it's a whole lot better than not knowing. And all of the abatements and the freezing of things are going to start opening back up again. So it's better to be prepared for it. Let me see. Okay, I've got some questions. So so they want to know the amount you got for the EEIDL grant. Will that go against what is forgiven? That has been gone back and forth. Nobody's sure of the answer, but I think yes, it probably will go against what's forgiven. At first they said no, then they said yes. The EEIDL was that everybody was supposed to get $10,000 when you applied for it. It ended up being less for most people. They gave you $1,000 per employee. It is supposed to be a grant though, so at the end of the day, I think you'll probably slide through. Again, as long as you were under 2 million, and that is on the forms as well, they are making you show the need. I think as long as you were under a minimum amount, that you probably are not going to need to pay back the EEIDL, or that will go against what's forgiven because it was supposed to be a grant. So, but I do think they want to know if you received it, and I don't think it's going to go against it. But it has gone back and forth. The last thing I saw is that it wasn't, and that seems to be, I've seen that it's not going to go against it more than it is. So, okay, what if an employee asked for reduced hours? They did give hours to other employees. I'm not sure exactly what the question is. If an employee asks for reduced hours, I don't really know how that would help them unless they had to take care of a sick relative, that's an issue, or they had to take care of kids at home that were homeschooling because of all of this. If that's the case, then there are very specific rules about that. The CARES Act did have a set aside for whether if your employee got sick themselves, or if they were taking care of somebody who was sick, or if they were home with their kids. So if it's one of those three categories, there is some specific stuff that you can do. Now, if you do end up paying people for that time, it is a tax break, so you get it back in the end. So yeah, and Bob, I'm not sure if I'm not answering your question, message me after, because I'm not sure if I'm answering it or not. Also, can you do a bonus for employees? And for sure you can do that. I mean, we did that. There were some people that had earned their bonuses for various things. I did pay it out of the PPP money. I did give almost everybody some hazard pay, depending on what they were, like a hazard bonus. But if there were people that were owed bonuses, I did do that. People that hadn't gotten a raise, or it would have been raise time, I did some of that as a bonus in a lump, as opposed to give them a raise over time for the year. So yeah, anything that you can do in that regard is fine. I mean, again, just make sure they don't go over the 100,000. So if it's an employee that already is getting 100,000, don't bonus them because you won't get forgiven for it. But if it's anybody under 100,000, whether it be a bonus, their raise, or whatever, you totally can do that, and I did that. If your payroll is at the end of 8 weeks, so say you're at the end of the 8 weeks, you're in you're in the middle of a payroll period, you do extend out to the payroll period, like the 9-week payroll period. So say your payroll happens every 2 weeks, even if you have a payroll once a month, and your payroll ends, your payroll is in the middle of the 8-week time period, you can bump it to the next one. So yeah, that happened to us. We had 1 week in our 8 weeks, and 1 week is week 9. We can use the week 8 payroll, even though it's over a payroll period, for the loan forgiveness. So basically you use half, and we're in that same boat, Jamie. So when you do your payroll tax return, they're going to want to see that. And if you get a payroll report from your payroll company, you'll just have to pause it in the middle. I think I've answered all the questions. Again, if you do have any, put it in the chat, send it to our Facebook page. That's everything that I wanted to talk about. We do have a couple more of these coming up. Like I said, I will update it when it's very important. But if you have any topics that you want to know more about, we're going to start doing these every other week. We went on an every other week schedule. But if you have any suggestions for what you want to hear about, let me know. We'll continue to update you. Thanks for your time and attention. Have happy to be here as a resource for you. If you have any questions, let us know. I do have some resources for an accountant if you don't have one to kind of help you walk you through this. I also have a couple cleaners. They are all redoing their pricing structure and trying to make it easier. I'm supposed to get some today. I'll put that out in my chat. There's a couple different ways to clean your area that basically will last for a little while, that does coatings and things that are antiviral. So I've got a little bit of that information if you're worried about it. And if you're interested in talking about a waiver or any of the other things, please get with us. Let me see one more question. Yes, I will do that. We read each other's mind. So, okay, thanks everybody. Good luck. Hopefully things are getting a little bit back to normal for you. And if not, reach out so we can help you. Have a good Tuesday.